Okay, great. Well, then we'll go ahead and get started. My name's Tal Goldin. I'm the supervising attorney for education, discrimination, and core services at Disability Rights Montana. Disability Rights Montana is what's called a protection and advocacy organization. There is 57 of them across the country, one in every state, the outlying territories, and then one in the Four Corners region that focuses on the Native American communities in that area. We are a federally mandated program. When Congress created the Rehabilitation Act of 1973, they also created this protection and advocacy system to protect and advocate for the rights of people with disabilities. And so we are an independent nonprofit, but we're endowed with some authorities under federal law to investigate allegations of abuse and neglect of people with disabilities in facilities and in the communities. That was sort of our original mandate. And then over the years, Congress has expanded the grants and programs. And so we really provide sort of the full panoply of legal-based advocacy and legal services to people with disabilities and on disability issues. And we'll talk a little bit more about that as a resource as we go through this presentation. So my expertise is really in special education and discrimination in K through 12 education. Well, I also supervised a core services unit here, and our core services unit provides information and referral and intake to the disability community in Montana. So I have a familiarity with the resources that we're going to talk about today, but in some of them, I'm not an expert. And Monica asked me to present this session on understanding state disability resources. And I thought, okay, well, how am I going to do that in an hour? Any one of these things that we're going to talk about today could be the subject of an entire multi-day conference. So these programs are deep and wide. What I want to do today is three things. I'm not going to do a deep dive on any program. We don't have the time for that. But I want to look at these services in terms of a systems approach to help you build a mental framework for where to look for the right services and how to think about them in terms of getting kids what they need. And then give you an overview of the federal programs that fund these state programs so that you understand where to look. If you understand the federal programs, then you can search for, how does this apply or how is this implemented in my state? Many of these programs are implemented at the state level, and they're called different things in different states. They're implemented by different state agencies. But if you understand the federal funding streams and the programs, then you'll understand how to find them in your state. And then the third thing, if we have time, I want to talk about this thing called the question formulation technique, which was developed by my colleagues at the Right Question Institute in Massachusetts. And it's really this wonderful, simple tool for teaching people how to self-advocate and ask the right questions, specifically in these governmental services and these sort of bureaucracies that operate and are the gatekeepers to these services. So I'll try to take questions as we go, but if we get tight on time, I might ask you to hold your questions to the end. Unless there's anything to begin, I'll jump in here. So talking about thinking in systems, and I think about, wrapping around an individual, a person with a disability, what are the systems of service that they need? And with that focus on getting to this sort of end goal of living independently and being able to exercise self-determination and living in community settings. And so sort of working backwards from that, I would think about, we start with education and making sure that you're getting the right services at the right time, starting from early intervention services from birth to age 3, and then in the formal education system through special education and other school-based services. And then the whole point of that is you look at, the federal special education law is to improve outcomes for vocation, independent living, and community living. The further education, employment, and independent living is the way the law says it. And so one of the things schools is supposed to prepare everybody for, not just children with disabilities, be able to work. And so that next system is the vocational system. And then along with that, you can't be very successful living independently and working if the basic needs aren't met. So we'll talk a little bit about that. And similar idea is making sure basic medical needs are met. And that's where sort of the legal component comes in. Many of the programs that we're talking about are programs to which people with disabilities have legal rights. And often they assistance advocating for those rights. And there's a legal component that's essential to these rights and also to carry them out and make sure that they're being accessed appropriately. I also want to take a moment just about the legal component to recognize that most or much of what we're going to talk about is underpinned in late 60s, early 70s, as in the civil rights movement, and out of a recognition that people with disabilities were being wholly excluded from community life, wholly excluded from schools, from employment, from access to the things that everyone else is enjoying in the community. And if we look at sort of the scope of the law from Section 504, from the first anti-discrimination bill, anti-discrimination for disabilities, 1973, and then you fast forward along that scope to the ADA in 1990, you start with this. It depends on the insurance that you're purchasing. Sometimes it depends on required coverages under state law or required coverages under federal law, and subject, of course, to copays and coinsurance. And so that's really not something that we can kind of globalize, but is really going to be defined by your plan and your plan documents. One thing to point out here, and we'll talk about the analog to this in public insurance programs, is that it is common for insurance companies to deny coverage, and that it's important to pay attention to those denial letters when you get them, and to make sure that you're attentive to any appeals deadlines or any opportunity you have to work with your physician to appeal coverage claims. And then to be thinking about, just in really egregious cases, that you may want to consult with a private personal injury attorney or plaintiff's insurance coverage counsel in cases where there really appears to be a bad faith denial of coverage. But again, those are sort of on the extreme. So Medicaid, we're going to spend a little bit more time on that. And what I've tried to do here is create this PowerPoint as a resource guide for you. So I hope you'll keep it. All of the links in here should help you identify more details about the programs we'll talk about and where to find them in your state. But broadly, you can kind of think about Medicaid in two umbrellas. The one is sometimes called state plan Medicaid, which is more akin to an insurance coverage, like a private insurance. So it's covering your medical needs. You go to the doctor, you get your prescriptions, you have procedures done. Those are more similar to a private insurance situation. But they are, Medicaid is a partnership between the federal government and states. And so states get to define, to some extent, what those coverages look like. And that is described in what are called the Medicaid state plan. and state plan amendments, or sometimes called SPAs. And you can find them. I've linked here. If you ever want to do a little bit of light reading, you can read your state plan. You can read the various amendments. They're amended all the time, and they're amended for a lot of reasons. Sometimes because they're changing federal law, sometimes because the states are trying to target a particularly vulnerable population, sometimes for cost control measures. So you can access them. They're not easy reading. They're technical. They're not made to be accessible to the general public, but they are there. And sometimes there are some plain English summaries of coverage that may be helpful. Medicaid eligibility is typically based on income and assets. And then in the case of people with disability, qualifying disabilities. If a person is on SSI, Social Security insurance, which is Social Security coverage for people with disabilities that do not have a work history, so typically young people. In most states, if you're qualified for SSI, you're automatically qualified for Medicaid. But again, that's a subject of the state plan and how the state administers Medicaid programs. Another aspect, again, this is still talking about the state plan, is what's called the EPSET, or Early Periodic Screening, Diagnosis, and Treatment benefit. That is not a waiver service that we're going to talk about in a minute. It is part of the state plan Medicaid that they're required to provide. And it covers children under age 21. It covers preventative care. It covers diagnostic screening and testing. It covers dental. It covers mental health. It covers developmental disability needs. And the catch-all, which is what I wanted to focus your attention on, is important. Is this sort of called specialty services? And if you read that definition, you can see how broad it is. Any additional healthcare services that are coverable under the federal Medicaid program and found to be medically necessary, and that's often the catch, is whether it's medically necessary or not, to treat, correct, or reduce illness and conditions discovered, regardless of whether the service is covered under the state's Medicaid plan. It's the responsibility of the states to determine medical necessity on a case-by-case basis. So what's important about that is it is not this sort of regimented list of coverages like basic state plan Medicaid. It has this case-by-case analysis of whether this is a medically necessary service. And so there's a lot of flexibility in that. And it's something that's worth asking about if you're dealing with a Medicaid agency, to say, oh, could this be covered under EPSET? And again, what that looks like in each state and how EPSET is implemented differs, but it's an important coverage to be aware of. So waivers is a big piece for people, and especially children with developmental disabilities, or other disabilities for younger kids. So what a waiver is, we call it a waiver because it's a waiver of certain traditional Medicaid program requirements. Some of those are technical, and I won't get into them in detail of what it is waiving, but it can also be a waiver of even income requirements. So most Medicaid is based on, when it's not based on disability, is based on people living in a certain level of poverty. And a waiver could be a waiver of those certain income requirements where you can go up to a certain percentage of the federal poverty wage. But there are also other provisions that can be waived. You don't really need to worry about what it's waiving. What's important is what's available. And the waivers are a way for the Medicaid system to target a particular population. So there are different categories of waivers. The one that is most beneficial and the one that you're probably going to interact with the most is what's called the Home and Community-Based Services waiver, or an HCBS waiver. So the HCBS is this big federal umbrella, and then each state can apply for these waivers. So some states have 2 or 3 waivers, some states have a dozen waivers. For example, in Montana, we have what's called the Big Sky waiver, which is for typically children with physical disabilities. We have a DD, developmental disabilities waiver, developmental intellectual disabilities waiver, and then we have what's called the SDMI waiver, serious and disabling mental illness. And so allows some specific services to be covered for those categories. But lots of other states have many more waiver programs. So some of the services that could be offered under a waiver are things like what would be called durable medical equipment under Medicaid, home modifications. I just recently litigated a case to put an elevator in a child's home. Certain amount of home-based care, whether that's a home nursing assistant or a CNA or a personal care attendant. There's a broad variety of what we wouldn't think of as sort of traditional medical insurance covered expenses that could be covered under waivers, and depending on how your state defines them. We also have waiver coverage for applied behavior analysis in Montana that could also be covered as a benefit under the state plan. There is some overlap. So for example, with durable medical equipment that could potentially be covered under the state plan, Medicaid, but under a waiver, it's called specialized medical equipment. It could potentially be covered there. What's important as well is that waivers are supposed to be the payer of last resort. So if there is another benefit that would cover it, if that's Medicaid, if that's vocational rehabilitation services, if it's potentially Social Security, SSI, or school under special education services, then a waiver will typically deny that coverage. They may or may not be an entitlement. This is important. In Montana, they are not an entitlement. And what that means is that there's a certain number of slots and there's a long waiting list. Some states, there isn't a waiting list. Some states, it's automatic. And so you need to check in your state. And if there is a waiting list, make sure you get your kiddo on there as soon as possible. Sometimes those waiting lists are years long. The next service, and again, this can be is typically a waiver-based service, is case management and targeted case management. And the case management and targeted case management are basically the same thing, except targeted case management targets a specific population, which could be geographic. It could be by the characteristics of the individual, like targeted case management for mental health or targeted case management for certain intellectual and developmental disabilities. But it's services that allow the person with a disability to gain access to the other services, to gain access to medical, social, educational, and other services. And what's very helpful about case management is often that's sort of the connective glue or the central point of contact for accessing all of these other services. So good case management, when it's done well, will make sure that the kiddo or the person with the disability is connected to the right vocational services, the right educational services, the right medical services, the right housing services. And it can be sort of that central point of contact. But sometimes it's also very practical, like how do you get your medical appointments? I'm going to drive you. I'm going to help fill out this application for this waiver service. So it is that connection that I think of between sort of theoretical services and boots on the ground actually getting them accomplished. it doesn't include providing the underlying service. It's access to the service. So the caseworker is not providing the medical service or the educational service. They're helping the person with a disability access the service. Again, it may or may not be an entitlement, and there may or may not be a wait list. And you would typically, you're going to access those through your state Medicaid agency. They're often contracted out to various social service agencies, but the central point of contact would probably be the state Medicaid agency initially to say, who are the case management providers in the state, in my jurisdiction, in my area, and how do I get connected to them? Any questions so far? Okay, so the next sort of domain is financial and basic needs. And starting with the Social Security. So SSI, again, is not based on a qualifying work history. So if you think about SSDI, it's almost like a long-term disability insurance that you might buy privately. So that's a person who's worked for a while, has a Social Security work history, and was injured or acquired a disability, and now has a substantial limitation on their ability to work. They may be qualified for SSDI. Children typically don't have that work history, and so they're looking at SSI. And for children to qualify, there needs to be blindness or another qualifying disability and income and resource eligibility, which is typically considered at the household level, but that is very technical and I don't have time to get into. So the actual qualification of what is adequate to meet the income restrictions and the resource eligibility restrictions is a very case-by-case analysis. There are some things that qualify and some things that don't qualify. But there's actually some decent information on the Social Security Administration website, and I've linked those there. And we're going to come back to this needs-tested benefits in a minute here, because it's important in terms of financial planning. For basic income and food, there's the SNAP, TANF, WIC, and LEAP programs. So LEAP is Low Income Energy Assistance Program. It helps people living in poverty pay their utility bills. And SNAP and WIC are food programs. WIC is specifically for women, infant, and children. TANF is a temporary cash assistance program. Those are all typically accessed through state offices of public assistance. And I've linked there where you can find your state SNAP agency, which is typically going to be the same agency that administers TANF, WIC, and LEAP. Child Care Resources is another federal government program that funds potential child care in the states. And I've linked there as well where you can find those agencies in your state. And then Head Start and Early Head Start, which are also typically income-based, are early intervention. In the case of Early Head Start, is an early intervention program. And then Head Start is essentially preschool program for low-income individuals, not necessarily people with disabilities, but Early Head Start and Head Start typically or commonly are implementing other early intervention programs that are for kids with disabilities. The community action agencies, they're such a big umbrella that I'm not going to really get into, but just to touch upon that there is this big federal program called the Community Services Block Grant. And it is this massive federal program that provides for any number of social services programs in the state. So it's really not so much that you can find these agencies, but it's not so much that you're looking to target a specific service from one of these agencies, as that there's a funding stream that helps agencies that do social service work accomplish their work. And knowing who these agencies are, which you can find by clicking on these links, might help you find a sort of central clearinghouse for social service agencies that can connect you to more specific services. So because we've talked about these needs tested benefits, I want to talk about two financial planning things which are important, because they are really created for the purpose of maintaining people under this asset cap. And for Social Security, for SSI, there's typically a $2,000 asset cap. So in other words, you can't have more than $2,000 in assets and continue to qualify. And what those assets are, there's a lot of exceptions. Like you can have one individual car that may be worth more than $2,000, but you can't have an extra car. So there's a lot of things that would potentially, you'd think, oh, I'm over that $2,000 asset cap, but you're not. But be aware that it's there. And so an ABLE account is one way that Congress created to make it easy to put some money away for a person with a disability, and not violate this asset cap and have them lose their needs tested benefits. And ABLE accounts, if anybody has like a 529 college savings account, they're very similar, and they're kind of built on that same model where it's a bank account that is specific and has restrictions on what you can use it for, that's disability related. But the restrictions are pretty broad. It can be housing, it can be some food, it can be medical, uncovered medical expenses. And it's a bank account. You have to be a person with a disability to have it. You get a bank card like you would at any other bank. And they do most ABLE accounts, they're state-run programs, but you don't actually have to be a resident of that state to use their state ABLE bank. So like I'm in Montana, I could use an ABLE account out of Ohio if I like that program better. Most of the good ones do a nice job of accounting for the expenses, because you can get audited on this account by the IRS. And so you do need to keep track of what you're spending that money on, just like, if you have a health savings account, that you'd need to keep track to show that these are qualifying expenses. But a lot of these good ABLE account banks do a good job of maintaining the records for you and have good accounting. So it's up to a $16,000 per year maximum contribution. So you can put up to $16,000 in that account per year. And under current tax code, anybody can gift anybody else $16,000 tax-free. So it's a good way potentially for parents to put some money away for their children's needs, children with disabilities, and not have a tax implication for that, or even for grandparents or family friends. And the first $100,000 in that account is exempt from the asset cap. So you have this $2,000 SSI asset cap. You could have $100,000 in an ABLE account, and you're still not violating that $2,000 asset cap. If you go to $100,001, that first dollar over $100,000 counts towards your asset cap. So now let's say you've got $2,000 in a non-ABLE account, and now you've got $100,001 in your ABLE account. You're now over the asset cap by $1. You've got $2,001 for SSI countable assets. So it is a really nice tool available. Now, if you have a much larger estate, and we're exceeding that type of $100,000 asset cap, there is a device called a special needs trust that requires an attorney who knows what they're doing to set up. There are a lot of rules and regulations about how to properly set up a special needs trust. And if you mess it up, you can have some serious tax implications. So if you're talking about a large estate, you definitely want to go see an attorney who specializes in special needs trusts and knows what they're doing. But the purpose of that is the same. It's to avoid these asset caps on needs tested benefits. Okay, so now turning away from basic needs and turning into vocational, and there are a couple of things I want to focus on, because as I talked about at the beginning, the whole purpose of many of the school-based programs is to get people to further education, employment, and independent living. And because of that, vocational training starts in the K through 12 system. And it's mandated in IDA. IDA is the Individuals with Disabilities Education Act. It's the federal law that creates the special education system and the IEP. If your child is on an individualized education program, that is a creature of the IDEA. It's a creature of special education and this federal law. And the IDA mandates that the IEP that is in place, will be in place when the child turns 16, must have transition planning. And it defines transition planning as a coordinated set of activities that's designed to be a results-oriented process focused on improving the academic, so that's important, academic, the math and science and reading, and functional achievement of the child. So it's not just academic, but what are the skills that they may need to be in a work environment. To facilitate the child's movement from school to post-school activities, including post-secondary after high school education, vocational education, like a trade school, integrated employment. And integrated employment means working alongside people who don't have disabilities, as opposed to what we call a sheltered workshop, which is a job where everybody there has a disability, and where, unfortunately, there are some that still exist, and people are paid a sub-minimum wage. People can be paid pennies on the dollar, pennies for the hour. Typically, that is what we call piecework, which they're doing a lot of repetitive assembly tasks, and that is paid, for pennies per piece. And at least from a disability rights perspective, we say if people with disabilities are doing valuable work, they should be paid like everybody else and no less than a minimum wage. And so that's what integrated employment, that's sort of what that reference means. Continuing in adult education, adult services, independent living, and community participation. So that long list of things that transition planning in the IEP is supposed to prepare this child for, through a coordinated set of activities. What is it based on? It's based on the child's individual needs. So it shouldn't be this district-wide, one-size-fits-all program. It should be individualized, just like the IEP is individualized to this child's needs, including and taking into account their strengths, preferences, and interests. Which means in order to do this properly, you have to understand what the child's strengths, preferences, and interests are, which means you have to do appropriate transition assessments, which the school is required to do. And what does it include? It can include specific instruction. It can include related services like occupational therapy, physical therapy, speech and language therapy. It can include community experiences, going out and having job experiences, doing internships, doing job shadowing or job observations. The development of employment and other post-school adult living objectives, so goals that the kiddo is setting, right, that the young adult is setting, and when appropriate, acquisition of daily living skills and functional vocational evaluation, right? So in order to be successful in employment, you may need help learning how to dress appropriately. You may need help learning how to feed independently or use the bathroom independently. And those are skills that can be taught in the K through 12 system as part of the transition planning process. And that last piece, as I mentioned, is based upon age-appropriate transition assessments. So that's really important. Each word there is important. They're age-appropriate transition assessments, right? So we're not, and I would submit to you that age-appropriate means intellectual age, not chronological age. In other words, if you have a child who's intellectually disabled and is functioning at a 6 or 7 or 8-year-old and happens to be 14 or 15, then you should be administering transition assessments that are capable, are appropriate to their level of understanding. So transition planning has to start by age 16, but it doesn't. But there's nothing in the law that says it can't start earlier. And what's important here is that for many children with a lot of intensive needs, transition planning should start earlier. It is always okay for you to go to the IEP meeting and go to the IEP team and say, we'd like to start transition planning this year at age 14, at age 13, at age 12. Okay, because we're anticipating that this child's going to need a lot in the area of transition to transition effectively to post-secondary life. And it's going to take some time to get there. And so we want to start that process now. The school refuses, they're required to give you prior written notice. They're required to put in writing why it is that they're denying the request and the basis for that denial. And then you have a right to go to due process, essentially sue them to argue that what you've asked for should be done. Hand in hand with school-based transition planning is vocational rehabilitation services. And used to be that vocational rehabilitation was typically thought of for adults, services to help adults get and stay employed. Now, recently, in the last 5-7 years, Congress has expanded that role with two programs that are related. And the one that we're really focusing on is what's called pre-employment transition services, or PREETs. What PREETs really does is it's not a program that in and of itself provides direct service. It's not like IDA that says you have to do X, Y, and Z in terms of direct service. What it does is it requires VR agencies to spend a certain percentage of their budget on these pre-employment transition services for kids that are transition age. And so those are coordinated activities that happen with the school, showing up to IEP meetings and making sure that there's smooth transition, going out and doing job fairs. There's a whole range of activities that a state VR service can do under PREETs, but know that it is supposed to be this tool for a smooth transition from VR, from school-based special education IEP-based transition to adult VR services. And so the key thing that you want to focus on there is making sure that you're asking when you start transition planning with the IEP, whether that's at 14 or 16 or younger, that you ask in writing for the VR person for the state, for that region or for that district to be invited to the IEP meeting, including any pre-ETS specialists that they have, pre-ETS specialists that they have. What that hopefully will do is get that bridge in place so that they start early on anticipating that this kid is going to come into the adult VR system. Let's put the tools in place now so that they have a successful transition to that system. VR, like many of these other services, it can be subject to what's called an order of selection, which is essentially a waiting list. It depends on the state. In Montana, for many years, we had very intensive orders of selection, and nobody was getting services. Nobody was getting new services for several years. It's starting to open up again as they've caught up on their budget, but that may be different in different states. So again, making sure you get after that early, especially if there is order of selection in your state, and get them on that waiting list as soon as you can so that they can get those VR services. VR services can be exceptionally helpful for kids and for young adults and for people transitioning to the workforce. They can do job training. They can do what's called supported employment. They can send somebody there from VR that the employer does not have to pay for to train this person how to do the job. They will coordinate and work with employers to help them look at the jobs that they think, oh, a person with an intellectual disability couldn't do this job. And then the VR counselor will say, well, wait a minute, how can we break down that job in a way that they can provide something useful and valuable to this employer that this person can do? And a great example I once heard in a training was a person with a severe intellectual disability who was capable of pressing a button on demand. And that's what they did. They pressed this one button in a factory that started a process. And that was their job, but they were able to do that predictably and on task. And they were, they got a great deal of satisfaction and payment for doing that job. And it was a necessary job. Somebody had to do that job. There was another person I'm aware of, that was able to stock shelves and return what they call go backs in a store. Things need to be returned to the shelf in the Walmart, and that was the job. And so VR came out, negotiated with the employer for creating this job and how they were going to pay it, and then went with this person and trained them on how to do the job. And the vast majority of that work was at no cost to the employer. So to find your state VR program, there's more information about the PREETS services here. I've got a link here for the Rehab Services Administration where you can read all about their programs and then finding your state VR program. Related to that, I want to point out that there is a program called the CAP program, Client Assistance Program. That is also part of the laws, that it's part of the Rehabilitation Act that also fund the protection and advocacy systems. CAP is a program that helps people navigate the vocational rehabilitation system. And so if you need help getting into the VR system and navigating that system and getting the right services for that system, contact the CAP program. Some of them, like ours, is in the same agency that holds the PNA, but sometimes they're separate. In some states, there's a separate CAP agency and a separate protection and advocacy organization. We have this umbrella organization, this national association called the National Disability Rights Network. That's the national association of all of the protection and advocacy systems and the client assistance programs. So if you click on that link, you'll find both the CAP and the PNA programs in your state. I'll briefly touch on Take It to Work. Take It to Work is a Social Security program to assist people. People often think that I have Social Security disability or SSI and I can't work, and that's not true. And the Ticket to Work program is designed to help people figure out how they can work and still maintain their disability coverage, or find a job that would allow them to work sufficiently to meet their needs and get off of Social Security. And these area work incentive coordinators are specialists in the Social Security Administration who know how to work the Ticket to Work program. And so that's how you can find them. So I want to talk a little bit about administrative review and appeals. As I mentioned earlier, it is very common in all of these programs, Medicaid, VR, Social Security. These are administrative programs. They're administered in some states by bureaucrats. And like everything else in the world, the quality of bureaucrats are naturally distributed. So you are normally distributed. So there are good ones and there are bad ones, and there are ones that are in between. And it is common in these programs to deny covered claims as a matter of course, and to put the onus on the person with the disability or the claimant to go and file an appeal and seek the coverage. And the reason they do that is purely economic. It's a cost control measure. If you deny and deny and deny, most people don't have the wherewithal to appeal, or don't even read the document that says that they can appeal, and won't appeal. And so there's automatically this percentage of claimants that you're not paying for even covered benefits. And so in my experience, it's always a good idea if you're denied coverage to appeal. What that also means is when you get all these programs subject, like any other government program, are subject to due process requirements, which means you're entitled to notice and an opportunity to be heard. And when you get a denial, you're supposed to get a letter that says you're being denied, and this is the justification for the denial for A, B, and C reasons, and here's the process for appeal. It is very important to read that mail because you have a timeline on all of those things, and they change from program to program how long you have and what the process is, but there's always a timeline for when you can appeal, and it's usually pretty short, usually 30 or 60 days or 45 days. So it's very important when you get a denial to read those letters And even if you're not sure and you think, oh, I might want to talk to a lawyer or call the protection advocacy system, file your notice of appeal to get that clock stopped so that you're not going to run out of your time. And then you may, sometimes with Social Security, it can take a year or a year and a half to actually get to a hearing. So you may have plenty of time to go get a lawyer and go through the appeals process. But if you don't file the initial request for the hearing, you've lost that opportunity. So very important to read those letters, follow the procedures. They're usually not very complicated. You're not having to file a brief or any kind of legal argument initially. All you're filing at the very first point is, I want an appeal. All I'm doing is asking for an appeal. And that you should be able to do by yourself just by filling out the form and saying, I'm asking for an appeal. I will say, in my experience, the number of people who get coverage just by filing the appeal, and even if they're unrepresented, is significantly higher than had you done nothing. So even just by filing that appeal and talking to a hearing officer, sometimes you'll get coverage even if you don't have a lawyer and you don't go through a whole litigation process. So very important to keep in mind. And then the last point is that you're entitled, just like everywhere else, you're entitled to ADA and Section 504 accommodations in any government benefits process. So if you need more time to brief something or to file that appeal, what's important is to respond and say, I want the appeal. I need an extra 30 days as a reasonable accommodation for my disability. I need to use an assistive technology device in the hearing process, or I need to use PART, computer-assisted real-time transcription, or a sign language interpreter in that process. They're required to